Testing, testing, testing. 1, 2, 3, testing.
Good morning and welcome to the Maryland Public Service Commission meeting for November 22nd, 2022. Before we get started today, we have meeting minutes from our last meeting, which was held 2 weeks ago on the 9th of November. All in favor of the meeting minutes, please say aye. Aye. The meeting minutes are approved. Good morning, Mr. Secretary.
Morning, Mr. Chairman. There are 11 items on today's consent agenda. Items 1 through 3 are applications for certification of renewable energy facilities. Item number 4 is a notification of assignment of contracts between Jasco Energy LLC and Median Energy LLC. Item number 5 is a notification of upstream ownership change and name change from NG Retail LLC DBA Think Energy. Item number 6 is an application for a license to provide electricity from Symbio Energy Partners LLC. Item number 7 is an application from T-Mobile USA Inc. for approval of construction of a generation station. And items number 8 through 11 are updated standard offer service rates from Potomac Electric Power Company, the Potomac Edison Company, Delmarva Power and Light Company, and Baltimore Gas and Electric Company.
Thank you. Do commissioners have any questions on the consent agenda? Commissioner? No commissioners. With that, with respect to item number 1, 2, and 3, I would move that we approve the applications and issue renewable energy facility ID certification numbers, direct the applicants to establish REC accounts with PJM Gas within 30 days of certification, and direct the applicants to notify the Commission within 30 days if the information on which the applications are based should change. With respect to items number 4 and 5, I move that we note the filing. With respect to item number 6, I move that we grant the company Symbio Energy Partners LLC a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct that company to file notice with the Commission within 30 days of any changes to the information in its application. With respect to item number 7, I move that we approve the application. And finally, with respect to items number 8, 9, 10, and 11, I move that we accept the tariff revisions for filing with an effective date of December 1st, 2022. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton?
Aye.
Commissioner O'Donnell?
Aye.
And Commissioner Richard?
Aye.
I vote aye. The motions are approved.
Mr. Chairman, item number 12 on the administrative agenda is a request from Dish Wireless LLC for a 6-month extension to implement phone numbers in 3 rate centers.
Good morning, Mr. Chairman and Commissioners. Pam Coates on behalf of staff. On October 21st and 26th of this year...
Oh, Mr. Wilson? Mr. Wilson, don't go anywhere, please. Thank you. I'm sorry. I'm sorry, Dr. Coates, for the interruption.
On October 21st and 26th of this year, Dish Wireless LLC, Dish, filed a request for a 6-month extension in which to activate number blocks in 3 rate centers in Maryland. Phone numbers are issued to phone carriers by the North American Numbering Plan Administrator in blocks of 1,000 numbers, called a number block or block. Once a carrier has been issued a number block, the carrier has 6 months in which to begin assigning phone numbers from that block. If after 6 months the carrier has not assigned any phone numbers from that block, it is required to return the block to the pool for use by other carriers. This becomes important when an area code is nearing exhaustion, which is currently the case in Maryland's 240301 area code. When Dish initially filed its request, the company had control of 10 number blocks, 4 of which were in the 240301 area code. The company has since returned 7 of the 10 blocks to the pool. 3 of those returned blocks are in the 240301 area code. Dish is requesting an extension on the remaining 3 blocks, one of which is in the 240 area code. Staff supports Dish's request for the following reasons. Dish is currently under an FCC mandate to build a nationwide 5G wireless network, and the company is requesting those blocks in order to meet a deadline which is part of that mandate. It is in the public interest for Dish to fulfill its petition in the wireless market. Dish has returned most of the blocks to the pool and is asking for an extension on only those blocks it deems necessary to meet its upcoming FCC deadline. The company's infrastructure build-out is 85% complete in the affected areas, and Dish plans to launch its 5G service in those rate centers in January of 2023. In addition, construction delays in building the network have been caused by supply chain issues which were beyond the company's control. And Dish is currently marketing its wireless service to customers ahead of the launch to be ready to activate phone numbers as soon as the network becomes operational. Thus, given that the company has supported the common good by returning most of its blocks, has incurred delays caused by circumstances beyond its control, is facing an FCC deadline, and is serving the public interest by increasing competition in the wireless market in Maryland, staff supports the company's extension request. Staff recommends that the Commission approve the company's request for a 6-month extension on each of the 3 requested number blocks. Thank you, and I'm available for questions.
Thank you, Dr. Coates. Do we have counsel for Dish Wireless with us?
They are
Commiss-
not here.
Thank you. Commissioner O'Donnell.
Thank you, Mr. Chairman. Dr. Coates, good morning.
Good morning.
I wanted to ask you, the buck sheet says 6 months. It's kind of nebulous term. Is there a date? What is the date certain?
The date certain would be 6 months from the date that the initial 6 months hit its deadline.
Okay, so assuming today, it would be 6 months from today.
It would be, no, far less than that. It would be 6 months from the day they were issued numbers, number blocks. 6 months from the day they were issued them, they were supposed to return them or file for an extension. They filed for an extension. So given that their filing was in October, but that was after a lot of work I did with them. I'm not sure the date. I could look it up if you need it, but it was in September. I'm pretty sure of that. So it would be 6 months from September, or from whatever that date was.
So that's an even shorter time period than I was envisioning. It may be important to do a date certain in case they would have to come back to us if they have further delays.
I can be sure that that date certain is specified by providing it to you after this meeting if you'd like.
That would be fine. I don't have a substantive problem with this, but I just was wondering where that would be memorialized and
It's memorialized at NAMPA.
okay.
NAMPA knows the exact date that those numbers were due back to them if they had not been used.
Okay.
So NAMPA has that exact date, and the extension would be 6 months from that date, which
Okay.
I can look up for you if you'd like.
Okay, yeah, if you could provide that later, just out of curiosity, so I had a sense of when that will drop dead again. Thank you, Mr. Chairman.
Commissioner Bubar.
Thank you, Dr. Coates. I agree with the recommendation. I had a couple questions which would be more appropriate maybe for the company, but I'll ask you just in case. Is there an explanation for the original request was for 10 blocks and it was pared back down to 3 blocks? Any insight on why they went with 10 in the first place and how they got to 3?
I'm afraid I don't know.
Okay. And then I'm sure you don't know this either, but I was wondering if you know anything about their marketing plan. And I was wondering, my specific question, is it focused on the area where the extension request is focused on, Salisbury, Fort Washington, I think? Because I went on yesterday and I tried to just Google them, and to get information on Boost Infinite, I had to give them my personal information to be able to, there wasn't just like a website that gave information on their marketing. So I was just wondering if you knew anything about their marketing plan.
I actually do have an answer on why they pared it down to 3.
Okay.
And then I will address your other question. They pared it down to 3 because they have to keep one numbering block in each of those rate centers in order to be able to port numbers. So if they have a customer who signs up who used to be with Verizon and wants to keep their phone number, they can keep their phone number, but only if Dish has porting capability, which requires that they own a numbering block in that rate center.
Okay.
So they kept one numbering block in each rate center to ensure porting capability. And in terms of their marketing, I'm afraid I don't know.
Okay. All right. Thank you.
Seeing no additional questions, I would move that we grant the company a 6-month extension to activate the requested number blocks in the Lexington Park, Salisbury, and Solomons rate centers. The vote begins with Commissioner Bubar.
Aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Thank you. I've been a little discombobulated this morning, and I neglected to announce a promotion. Promotion of Peter Wolson in his new role of Deputy Staff Counsel, a position previously served by Lloyd Spivak when Lloyd was promoted to the Staff Counsel position. Peter has been a senior attorney in the Staff Counsel division now for nearly 8 years and has continually performed at the highest levels, working on so many cases, including our supplier, retail supplier prosecutions. Prior to joining the Staff Counsel Division, for many years he was a managing partner at a law practice here in town, specializing in business and torts, including asbestos litigation. After finishing law school, Peter was an associate attorney with the firm of Frank, Bernstein, Conaway, and Goldman for several years, and then of counsel to Kenny, Vittori, and Robinson. He graduated summa cum laude at University of Maryland School of Law and earned 2 master's degrees, both at Cornell and Johns Hopkins. Peter, congratulations in your new role. Thank you for continuing your service to the state. If you have no other matters, you can now scoot through stage left. Thank you. Mr. Secretary.
Mr. Chairman, item number 13 consists of revised tariff pages from the Association of Maryland Pilots.
Good morning, Mr. Chairman and Commissioners. Lucy Shea on behalf of staff. By letter dated October 13th, 2022, the Association of Maryland Pilots submitted revised tariff sheets to be effective January 1st, 2023. These charges would apply to all vessels piloted in the Chesapeake Bay and tributaries. Maryland pilotage rates and charges are established by the Maryland Public Service Commission pursuant to Section 4-303 of the Public Utilities Article of the Annotated Code of Maryland. Services offered by the Maryland Association of Bay Pilots consist of 2 regulated rate structures. 1, the bay rates and charges, and 2, the docking rates and charges. By order number 77555, issued January 16, 2002, the Commission accepted a settlement in case number 8904 in resolution of an application to increase rates of the Association of Maryland Pilots for pilotage services within Maryland waters. According to the settlement, an annual Consumer Price Index inflation rate adjustment shall take effect on January 1st of each succeeding year, if requested. The settlement would be extended automatically until terminated by one of the parties through written notice. The settlement specifies using a consumer price index based on urban consumers issued by the United States Department of Labor using the most recent 5-year moving average. Staff reviewed the filing and verified that the proposed tariff rates properly reflect the Consumer Price Index 5-year moving average increase, which is 3.82%. Staff recommends that the Commission accept the proposed tariff for filing effective January 1, 2023.
Thank you, Ms. Shea. We'll now hear from the association.
Good morning, Mr. Chairman, Commissioners. James McGee with the Law Office of Robert Castro on behalf of the Association of Maryland Pilots. With me today is Captain Eric Nielsen, the president of the association. We don't have any prepared comments, but we're here to answer any questions that you may have.
Thank you, Mr. McGee. Captain Nielsen. I turn to my colleagues. Do you have any questions? Commissioner Bubar.
Thank you. I actually just have a question on the C&D Canal surcharge. Is that a charge for ferrying boats from the C&D Canal? I just really wasn't sure what that was.
That charge goes back, I think, into the 60s when it started, and it's to reflect the difficulty of going through that narrow waterway, and it just is carried on all those decades.
Okay, thank you.
Commissioner O'Donnell.
Yeah, first a comment to Captain Nielsen. Captain, life must be good down at the Bay Pilots because you always look so happy.
Things are okay. It could be much worse. That's why you see me smiling.
Ms. Shea, I wanted to ask you, if either party were to terminate the settlement agreement that has some longevity on it now.
Excuse me, Commissioner O'Donnell. I'm having a hearing problem this
Okay.
morning, and Jim has offered to.
All right.
I can't hear.
Okay, I'm sorry. So, Mr. Geiger, if either party were to terminate the settlement agreement, which has some length on it now, what would happen? What would happen? How would this matter be handled going forward?
Well, in order for a change of rates, there would need to be some sort of rate case or some sort of proceeding before the commission in order to authorize any change in the rates of the Pilots Association.
Okay. I guess with the question that's rising, this feels like an automatic inflator to me, an annual inflator. But is there any analysis that's done from the perspective of just and reasonable rates, or do we just continually inflate them annually based on CPI?
I believe the just and reasonable determination was made at the initial approval of the settlement agreement. That kind of set the formula that we've been moving ahead with. So I believe that the just and reasonable determination has already been made, but I would say that these increases require the Commission's approval moving forward, so like why we're here today. So there's still a Commission oversight over the increase.
Yeah, but conditions change, times change, things change, revenues and expenditures change. The Bay Pilots have changed during this time period. The organization has changed. The economic status of the world and supply chain. There's lots of variables here. Is staff doing a prudency review of these inflators? Is there any analysis of the just and reasonable? I'm pretty sure we're not. I'm not.
I can say once we receive these items, or once the application is received by staff, we do the analysis required to present our recommendation at this administrative meeting. Beyond that, if there were a change in circumstances that would require a change of rates, then any party to the original settlement would be able to bring that forward and request a new rate case. In this case, it might be more appropriate for the Pilots Association to bring such a case forward if they felt that there was a change of circumstances that would warrant a change of the rates.
Yeah, something doesn't feel right here to me that there's no at least analysis, some periodic analysis. And although the just and reasonable determination may have been made all those years ago when the settlement agreement was entered into, I don't know that still applies today. I don't have a level of confidence that there is any analysis going on of that. So, Captain Nielsen, what's the Bay Pilots?
Well, and this goes back to when we had this case and the debate about whether we should adopt this kind of escalator. And the realization was that our customers are very sophisticated. These are shipping lines, international shipping lines, and they know what they're doing. So it is not a matter of protecting people like me with BG&E rates. Our customers know what they're getting into, and they review this all the time and are relating it to the costs they see at every other port, and they're satisfied. So for us, we look at it as a long-term solution. Obviously, with our 3.8% increase this go-around, we're well behind inflation, but we expect and hope that we'll recoup some of that in the future rate increases, and we just run our business as efficiently as we can. Historically, we would wait and hold major expenses like replacing our harbor pilot launches, which now run about $2.5 million each. We would wait and propose those at a rate increase to justify a very large increase periodically. Now we just buy those, and I just signed a contract a month ago for 2 more because we think that this is going to keep going, and we just run our business efficiently, and industry appreciates that, and they also are pleased that they can. The increases are predictable and moderate. The other groups that don't have the ability to do this are looking at legislative changes, or the pilot commission itself will have an increase, and they tend to be much larger, and they are more erratic. So what we're doing here is really was held up as an example for other states to use, and in fact, over in Seattle, they did a countrywide search for what is the best method, whether it's legislatively or pilot commission or public service commission or utilities commission as they have there, and they adopted our method because it provides a very good relationship between the pilots and industry, because we do have to work together for everything else. So it's yes, it's getting long in the tooth, as they say, but so far it seems to be working.
Yeah, no, I appreciate that, and Mr. Chairman, I appreciate as well that rate cases can be messy, and they can consume a fair amount of resources, both staff, the party itself, and other interveners who may come into it, but there's also the consumer to think about. So I know you think about your customers, but I think we need to think about the economic well-being of the state and the consumers of the state who ultimately will bear the freight, so to speak. I just wonder, without upsetting the apple cart of a settlement agreement, which may be appropriate, if there's some kind of periodic analysis that can be done to say, yeah, here's where we think the rates should be, and here's where they are, and it makes sense. Maybe it will validate this process. Or if it's not, if something's out of whack, then we could learn that too. But I'm not sure that analysis is going on or will go on. We'll just keep plugging along every year, escalating the rates. And I'm not sure that feels right to me without any analysis to back it up.
Well, there was, I think it was 5 or 7 years ago, there was an analysis done just to see if the inflationary escalator was appropriate, and so we provided data to staff, and it was reviewed, and it turned out that it was working remarkably well, because the CPI doesn't really accurately reflect our expenses as a business. It was just chosen as something we could all agree on at the time. But it did turn out to work. At that point, it was working pretty well. And so that data is not that old. I forget exactly when it was, but we'd be happy to do that again too.
Okay. Maybe that's a project that staff could consider taking on, as described by Captain Nielsen.
Yes, Commissioner. I think we would be very appreciative if the Pilots Association were to provide that data.
They just said they were willing to cooperate with that. So I think that might be a way to move along, not upset the apple cart, but at least give some due diligence to this rate-setting escalator. So thank you, Mr. Chairman, for indulging me.
Thank you. I would move that we accept the tariff revisions for filing with an effective date of January 1st, 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 14 consists of filings regarding the Universal Service Trust Fund surcharge from the Maryland Department of Disabilities.
Thank you. Do we have somebody from the department with us today? Mr. Davis, you're all alone.
Good morning, Commissioners. My name is Hunter Davis, and I'm Assistant Staff Counsel. Before you is a recommendation that the Commission set the surcharge paid by the subscribers of communication services for funding the Universal Service Trust Fund to remain at 5 cents per month per account for fiscal year 2024. The Maryland Department of Disabilities filed its USTF annual reports for fiscal years 2019, 2020, and 2021. By law, the Secretary of the Department of Disabilities is required to certify with the Commission the costs of the program to be paid by the USTF. These programs include Maryland Relay, Maryland Accessible Telecommunications, the Deaf-Blind Communications Facilitator, Senior Call Check Service, and NFB Newsblind, which is the news service for the blind. After data requests and discussions with MDOD staff, projected costs and revenues demonstrate that USTF could be reduced to zero by fiscal year 2025. However, MDOD has acknowledged an increase to the surcharge may be appropriate in the future. At this time, MDOD is requesting that the surcharge remain at 5 cents. Thus, Commission staff is recommending that the Commission keep the USTF surcharge at 5 cents per month per account. Thank you.
Thank you, Mr. Davis. Any questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Davis, draw your attention to page 5 of the buck sheet, table 1. And it seems to indicate there was no filings in 2019, 2020, and 2021. The 3 years blocked out. But if you flip the page to page number 6, the very last paragraph before the recommendation, it only talks about no filings in 2020 or 2021. No mention of 2019. So there seems to be a disconnect between table 1 and the verbiage that describes 2 years of the 3 years that weren't filed. So can you clarify that for me?
I believe that was a mistake. So the filing, there was a change in the organization of the overarching agency that oversaw the DoD, and so in between that change, we were told that the Telecommunications Access Maryland, who prepares these reports, just did not, I guess, forgot to make these filings, and so when they made their filing this year, they made also the 3 missing years filings, and so I believe that this was a typo in the buck sheet. That only includes 2020 and 2021, but it should be.
When did that organizational structure change? Do you know?
So I know in the most recent legislative session, it was reorganized to be within the Department of Human Services. It was formerly in the Department of Information Technology, and so I believe that was from 2019 to 2020 to the most recent legislative sessions. That would be this year.
Okay. All right. Very good. That's all I have. Thank you, Mr. Chairman.
Thank you. The vote begin. Motion. I move that we set the surcharge at 1 nickel for fiscal year 2023. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. The final item, Mr. Secretary.
Mr. Chairman, item number 15 is a request from Richfield Solar Energy LLC for an extension of an operational deadline in case number 9457.
Thank you. Good morning.
Good morning. Good morning, Mr. Chairman and Commissioners. Christopher Lowe on behalf of staff. On September 22nd, 2022, Richfield LLC filed a request for 1-year extension of the operational deadline set by Condition 3 of the Certificate of Public Convenience and Necessity in case number 9457. Pursuant to the current CPCN Condition 3, Richfield is required to commence operations by March 19, 2023. However, Richfield has experienced delays in interconnection facilities upgrade and issues associated with the solar module supply industry that prevented the company from meeting the project's operational deadline set forth in the original CPCN conditions. According to Richfield, a substantial progress has been made on the construction of the project. and the company and Delmarva Power have also worked closely to accelerate the construction of the required interconnection upgrades in order to meet the planned backfeed date of October 26, 2023. However, the recent passage of the Uyghur Forced Labor Prevention Act has disrupted solar module supply chain and pushed the operation start date beyond the project's expected COD. Staff believes that Richfield has acted in good faith and has worked diligently to advance the project. The company has presented good cause for the Commission to extend the deadline to commence operations imposed by the CPCN Condition 3. Granting Richfield's request would allow the company to complete construction and begin operations within a reasonable time frame. Staff recommends that the Commission grant Richfield Solar's request for a 1-year extension of the operational deadline set by CPCN Condition 3 for good cause, and approve the revised license conditions filed by PPRP. Thank you.
Thank you, Mr. Lowe. We do have revised conditions filed by PPRP. Ms. McElmore, would you like to add anything? We've reviewed your documentation.
No, Commissioner. Sandra McElmore on behalf of the Power Plant Research Program. We did file those conditions, the revised conditions recommended to bring them up to date to other CPCNs, and we have no further comments at this time.
Thank you for working with the developer in the interim. Counsel for Richfield Solar LLC.
Thank you, Mr. Chairman, Commissioners. David Bugelmans on behalf of Richfield Solar LLC. I also have with me Mr. Eric Dowdy from Invenergy, the owner and developer of this project. As Ms. McElmore indicated, we worked with PPRP over the last several weeks on some tweaks to their proposed revisions to the CPCN conditions. Effectively, this project is largely constructed, so it was important to make sure that those conditions reflected the reality on the ground, but we reached an agreement with them. We support the most recent conditions filed on November 18th. On the merits of this request, I don't have much to add to Mr. Lowe's presentation. Again, this is a project that has been largely constructed by the developer. About 100% of the civil work on this site's done, 90% of the racking's installed. The racking's been tested, so once the panels are able to be imported, they will be able to ramp up construction and get them installed as quickly as possible. So again, I won't reiterate the points in our filing, but we're here to answer any questions. We appreciate your consideration.
Thank you, Mr. Bugelmans. Questions from the Commission? Commissioner O'Donnell.
Thank you, Mr. Chairman. I know you're surprised. I'm going to ask you some questions, Mr. Bugelmans. So the oppression of the Uyghurs is terrible, and there's good reason that there's a federal act kind of putting some economic pressure on to stop the oppression and persecution of that group of people by the Chinese Communist Party. But I don't expect that that's going to stop anytime soon, and I don't expect any abrogation of the act, certainly not in the next year. So how do you solve that problem if that's the real reason? If that's true, that you can't get these PV panels because of the Uyghur Protection Act, what makes you think it's going to change in a year?
Yeah, I can't speak to the broader industry, but I do know with this request, effectively it's a rebuttable presumption, and so Invenergy submitted documentation that shows that the materials used in these panels are not from the affected regions. So the expectation is that eventually Customs and Border Protection will approve that documentation and allow these panels to be imported. So that's how the project's addressing that issue for this project.
So I'm not sure that answers my question, but my understanding is there's some workarounds where these panels are being manufactured where they've always been manufactured. They're going to third parties to kind of obscure the track of the panels, and then they come to this country kind of circuitously. Is that your understanding of how this is working right now in the industry?
I'm not aware of broader industry trends, Your Honor.
Does the developer have a sense of that?
Not really.
Well, if you're going to use that as an excuse, you better be able to explain it.
No, I do know that the previous regime, WRO, kind of had similar, we've used similar reasoning in the past, and kind of based off of that timeline of how we were able to get panels in, we're using a similar assumptions for this regime as well.
I had a real hard time hearing what you said.
Sorry. Based off of the previous regime's WRO, we basically, the same panel kind of workarounds were being used, and we kind of anticipated a similar timeline and schedule based off of that.
Okay. So, Mr. Bugelmans, you know I'm frustrated that state policy isn't being implemented. We get delay after delay after delay after delay after delay. And I'm kind of like, I've had it up to here. I want state policy implemented because that's my job to make sure it is. And yet, you seem to be constantly before us with one excuse or another that we're not implementing, not allowing us to timely implement state policy. We got some deadlines to meet. And this string of delays in these projects isn't helping us meet them. What do you have to say to that?
Well, I think the message has been heard loud and clear by the industry. And I think this request in particular reflects what the message that we've heard from the commission, which is that these projects need to be aggressively pursued as much as possible. So, I mean, again, here we have a project where the project is advanced as literally as far as possible in terms of construction. And they'd actually demobilize to allow these issues to play out. So I think the industry's heard it loud and clear. I recognize it's frustrating. It's frustrating for the industry as well. I mean, again, the demobilization costs for this site were approximately $1.5 million. So there's an impact on industry as well. And I think this is an example of a developer that's doing everything they can to move this forward and help achieve the state's goals.
Do you have a feedback date from DPL?
Yes, the feedback date is in October 2023. So they were hoping.
Why is it taking them so long?
I think this is something that's been reflected with other projects in the DPL territory. My understanding is there's just a backlog of work, reviews, and then once agreements are finalized, it's just taking the utility a long time to be able to move forward with upgrades, and it's impacting the entire industry, not just this project on the Eastern Shore.
Well, there's an area you and I probably agree on, and that a preponderance of these seem to be in the DPL service territory. So I don't know why. I don't know why it's not more endemic, if you will, more ubiquitous across the state, and seems to be concentrated on the Eastern Shore and DPL. And these interconnection agreements, and I fail to understand why. There seems to be a lot of finger pointing. The developers point to the utility points to PJM. PJM says we're doing everything as fast as we can, but there doesn't seem to be any accountability on kind of retarding the state's ability to meet its goals, its energy goals. And I'm trying to figure out why and who's really responsible here instead of all of this all the time. Maybe I'll ask Mr. Mike Keel if he would mind coming to the microphone and giving us DPL's perspective.
Doug Mike Keel on behalf of Delmarva Power and Light. With respect to this project, Your Honor, we have been meeting consistently with the developer and working through the issues that we have. My understanding, and Mr. Dowdy can correct me if I'm wrong, there's some backfeed issues that we're working through to make sure that the system works as designed, and we're working in good faith with all alacrity to get this project underway. And as Mr. Bugelman said, there's the October, I believe, 23rd date that we've agreed to meet.
Why does there seem to be a concentration of these delays with Delmarva Power and Light?
I don't have that answer today, Your Honor. I don't know if it has to do with where the projects are located and the need for system upgrades. So there could be a myriad of reasons. I don't know, standing here today, what those reasons are. I do know, like I said, it's the backfeed issue with respect to this project, and we're working diligently with the developer to get those issues resolved.
Does Pepco have this problem?
I don't know.
Well, you represent them.
I do, but I need to be prepared for questions that come, and you may think that I know everything that's going on in the company, but that's just simply not true.
I understand.
But I'm happy to get those answers if you would like, and bone up on these very important issues with respect to state policy. I can tell you this, that the PHI companies are committed to meeting those state policies, and we're not in any way, shape, or form dragging our feet. I know that, and I did review some of the email chain with the company related to this, and I think what Mr. Bugelman's put in his letter is correct, that on page 3 that we're working in good faith with the developer to get this in place.
Well, all I can tell you is we get delay after delay after delay, extension after extension after extension. I don't know if it's financing. I know what it's not. I know it's not the frozen tundra of Maryland, which we heard for a long time, and that we don't hear that anymore. But there seems to be an endless stream of excuses and finger pointing, and everybody says, yeah, we want to do this, but it never gets done. And that's why we have these deadlines, so they don't delay forever. And so I'm saying to all the parties, yes, I'd like some answers. I'd like some answers as to why you're delaying implementation of state policy. And there may be, down the road, maybe a way for some accountability on some of this stuff, because there doesn't seem to be any now. That's all I have, Mr. Chairman.
Thank you. Additional questions? Seeing none, I would move that we grant the company's request for a 1-year extension of the operational deadline set by CPCN condition number 3 for good cause, and approve the revised license conditions as filed by PPRP on November 18, 2022. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
No.
Commissioner Richard.
Aye.
I vote aye. By a vote of 4-1, the motion carries. Before we conclude today's administrative meeting, actually, we're going to be continuing our administrative meeting technically in a few minutes to handle the BGE lessons learned item in case numbers 9618 and 9645. We'll begin that promptly at 11 a.m. this morning in that manner. With nothing else for this component of the administrative meeting, we are adjourned.